Hey, welcome. So today, we're going to break down the entire disciplinary process you might face in a South African workplace. We're going to make sure you understand every single step and, more importantly, what your rights are. Let's start right there. You get that notice for a hearing and your stomach just drops. It can be so stressful. But honestly, getting a handle on the process, that is absolutely the best first step you can take to walk in there with some confidence.
Okay, let's dive right in. See, to really understand any disciplinary inquiry, you've got to grasp the two big ideas that the whole thing is built on. These are the core principles from the Labor Relations Act. So think of fairness as being split into two really crucial parts. First, you've got the why. Is there actually a good reason for this whole thing? And second, there's the how. Was the process itself, the way the hearing was run, was that fair? Both of them have to be in place for the outcome to be considered just.
Okay, so this is so important. Your employer can't just take action against you because they feel like it. There has to be a real work-related reason. We're talking about things like proven misconduct or properly documented poor performance. They need a solid why. And here's the other side of that coin. Even if there is a valid reason, the process itself has to follow the rules of the game. And that's there to make sure you get a real, honest-to-goodness chance to be heard and to defend yourself. All right, so let's see how all of this builds into a practical toolkit, a set of specific rights that you are guaranteed during any hearing. Knowing these is your absolute best defense. First up, your rights kick in before you even set foot in that room. You have to be told, in writing, exactly what you're accused of. And you have to be given enough notice and time to actually get your side of the story straight. No surprises, no last-minute rushes. Now, during the hearing itself, you're not just sitting there passively. You have the right to have someone there with you, to present your own evidence, and, this is a big one, to question the witnesses they bring against you. That's your chance to really test if their story holds up. And finally, the process is designed to be impartial, which is why you have a neutral chairperson. You also have the right to be told the final decision, and you have the right to challenge it later if you believe the whole thing was unjust. Okay, so you know your rights. Now let's pull back the curtain and look at how a typical inquiry actually plays out. What can you really expect on the day? Without a doubt, the most important person in that room is the chairperson. You've got to think of them as the referee. Their job isn't to side with the company. It's to make sure the rules are followed and that both you and the employer get a fair shot to present your case. They have to base their decision only on the evidence presented in that room. The hearing itself follows a really clear, structured path. First, the employer gets up and lays out their case. Then it's your turn. And after hearing everything from both sides, the chairperson has to step back and weigh it all up objectively before deciding if you're guilty or not.
So what happens after the chairperson has heard it all and made a call? Let's take a look at how a fair sanction or punishment is actually decided.
Right, so if the verdict is guilty, the outcome isn't just pulled out of a hat. The chairperson has to consider a bunch of things. How serious was the issue? What's your track record with the company like? Do the company's own rules say anything? And this one's key, did you present any mitigating factors? Personal circumstances that could explain things. But what happens if you walk out of that hearing just feeling like the whole thing was a sham? Maybe the process was flawed, or the outcome was just way too harsh. Well, it's not over. You aren't stuck. You have options, kind of like a safety net. And you need to pay very close attention to this number. If you were dismissed and you believe it was unfair, you have only 30 days from that dismissal date to refer your case to the CCMA. That deadline is super tight, so you can't hang around. Now, for other stuff, let's say you got an unfair final written warning or something that isn't a dismissal. Well, the window's a bit wider. In those cases, you have 90 days to refer it as an unfair labor practice. So this table here basically lays out your two main game plans. First, and this is a big one, check if your company has its own internal appeal process. That's usually your first stop. If they don't, or if that appeal fails, then your next step is heading to the CCMA or the Right Bargaining Council.
So the real takeaway here is that these rules, they're not just there to protect employees. A process that's fair and transparent actually builds trust and stability for everyone. It's good for the employees, and it's good for the employer. At the end of the day, it's about basic justice in the workplace.
So we're going to leave you with this last thought. Knowledge really is power. Just understanding these rights is the first massive step. but actually using that knowledge to stand up for yourself, that's what really ensures fairness wins out.